Hi everyone, I'm Catherine with Visa Harmony. Today I want to talk about what happens to the petition if unfortunately the petitioner dies. We at Visa Harmony, we provide assistance with certain U.S. petitions and immigration applications. We have first-hand experience. I am an immigrant myself. I came to the USA on a K-1 visa in 2013, went through the entire U.S. immigration process. First the fiancé petition, then the adjustment of status, removal of conditions, and I became a naturalized U.S. citizen in 2017. I will leave our contact information below. If you're an immigrant who has applied for a green card based on a family relationship with a U.S. citizen or permanent resident, you may be wondering what will happen to your case if your relative petitioner passes away. Will you lose your chance to immigrate to the USA, or can you still continue with your application? The answer depends on several factors, such as the type of petition, the date of death, and the availability of a substitute sponsor. In this video, we will explain the different scenarios and options that you may have in this situation. First, let's talk about the general rule. According to the Immigration and Nationality Act, INA, when a petitioner dies while the petition is pending, the petition is automatically revoked. This means that the immigration benefit that you were seeking through your relative is no longer available, and your case will be denied or terminated by the USCIS. This rule applies to all types of family-based petitions, whether they are immediate relative or preference category petitions. However, there are some exceptions to this rule. In 2009, the U.S. Congress passed a law called the Family Sponsor Immigration Act, which created a new provision in the INA known as 204I. This provision allows certain beneficiaries of pending or approved petitions to continue with their immigration process even if their qualifying relative dies, as long as they meet some requirements. These requirements are: number 1, the beneficiary must have resided in the USA when the qualifying relative died. Number 2, the beneficiary must continue to reside in the USA on the date of the decision on the pending application. And number 3, the beneficiary must be one of the following: a spouse, child, or parent of a U.S. citizen, a spouse or child of a permanent resident, a married son or daughter of a U.S. citizen, a brother or sister of a U.S. citizen, a derivative beneficiary of an employment-based petition, a beneficiary of a refugee or asylee relative petition, a derivative T or U non-immigrant, or a derivative asylee. If you fall into one of these categories and your qualifying relative dies, you may be able to request for USCIS to reinstate your petition through the I-204I relief. You will need to submit evidence of your eligibility, such as proof of your residence in the USA, your relationship to the deceased relative, and any hardship that you would face if your petition is revoked. You will also need to find a substitute sponsor who can file an affidavit of support for you to guarantee that you will not be a public charge in the USA, unless you are exempted from this requirement. A substitute sponsor must be a U.S. citizen or permanent resident who is at least 18 years old and related to you by blood, marriage, or adoption. I will put the link below for more information on the Section 204I relief. Another exception to the general rule is for widows or widowers of U.S. citizens. If you were married to a U.S. citizen who died before filing a petition for you or before the petition was approved, you may still be able to self-petition for yourself using the Form I-360. We created a separate video on widow or widower visa, and I will link it below. If the beneficiary is not a spouse and not living in the USA when the petitioner dies, they may not qualify for the 204I relief. In that case, they may have another option called Humanitarian Reinstatement. This is a discretionary solution that allows USCIS to reinstate an approved I-130 petition that was revoked due to the death of the petitioner, based on humanitarian reasons. This option is only available if your petition was approved before the petitioner died and if the beneficiary has an available visa number. To request for humanitarian reinstatement, the beneficiary needs to make a written request with supporting evidence to the USCIS office that originally approved the petition. I will put the link below for more information on humanitarian reinstatement. As you can see, there are possibilities for you to continue with your immigration case even if your petitioner dies. However, these options are not guaranteed. You will need to follow the proper procedures and provide sufficient evidence to the USCIS to prove your eligibility and merit for these benefits. You may also encounter some challenges or delays in your process due to the death of your relative. I hope this video is helpful. If you have any questions on this topic, please post them in the comments section below or send us an email at ask@visaharmony.com. Thank you and see you next time.